connecting up to anyhow yeah, I was just thinking between a little bit of transformative use,
Okay.
basic understanding of the different copyright forms that they might encounter or put to use, like mechanical, going over mechanical rights,
Licenses. Yeah.
yeah, and all that. Just kind of hit the highlights there.
Okay.
I figured you had to deal with enough musicians where you see a lot of the same questions coming up again and again.
Yeah. Yeah. It does. When it comes to things like, sampling and that sort of thing and all the urban myths that go around what you can and can't do.
Right.
Yeah.
That's right. Yeah. Like one of the, I think I emailed you about one of the questions I put on the midterm was, you can do whatever you want as long as you don't make money off of it.
That's not the test.
Right.
I just kind of briefly looked at it this morning, the PowerPoint that I used the last time that we were together. And I'm actually a little hesitant to use it because I don't know if I can use those images in this format. Not a traditional four wall classroom, the way that copyright law would allow me to use for educational use. So,
Yeah, yeah, it gets very meta very quickly. And yeah, I guess this speaks to a lot of what you deal with is the technology racing faster than the law
yeah.
and not really knowing what to expect. One thing that we're dealing with currently on Facebook and YouTube is that we stream a lot of our concerts.
Okay. Hmm.
So uh, that is another performance.
Exactly. And Facebook, understand, just shut that down.
Very hard.
They shut it down very hard. And I have to tell you, I'm proud of Facebook for doing that. I think that they were a good corporate citizen in doing that.
Hmm.
You know, if you look at the year 2018, intellectual property accounted for more than 38% of our gross national product. That's more than one third of our economy in GDP is intellectual property.
Yeah.
And so if we don't protect that ourselves, we're just damaging ourselves if we don't protect our interest in intellectual property.
Right. Oh, totally, totally. Yeah. And as a musician, I have to remember when people say intellectual property, they're not talking about songs necessarily. They're talking about.
Food songs. So
Right.
intellectual property, is proper. It's patent law, which I'm not really equipped to talk about. I can give you just the basic outlines of patent law, but that's
Right.
for our inventions. Those are things like the patent to how you make an iPhone or the patent to how you make a Bose speaker. Now, the music that comes out of that Bose speaker is another form of intellectual property that's
Mhm.
protected by copyright. And so that's probably the area I think that your students are probably most interested in.
Mhm. Yeah. Not to get off on a tangent too much, but I remember a few years ago I was having a discussion with Andy Wilhite, and he made some commentary about how America led in innovation of engineering, and China led in the ability to backwards engineer.
Yeah.
And at the time, I was like, oh, that's possibly part of the culture, the way they're thinking, whatever. And then it wasn't until I spoke with you years later, it dawned on me, it's like, no, because there's no safeguards for them.
That was a moment for me a few years ago. I had a graduate student. She was from China, and she came to my office and she had this epiphany. And she came in and she said, I finally get it. Americans are not the smartest people in the world. And I thought that was obvious to everyone. But why would you think such a thing? Why would you think that Americans are smartest? And she goes, well, everything comes out of the United States. Every invention, every song, every movie, software, everything comes out. And so from her perspective, she thought Americans were just super, super bright. She goes, but now I understand that you have a legal system that will protect the property interest in the things that people create. She said, why would anybody in my country invent something? Why would you spend years in educating yourself and developing your skill set to create something that will immediately be stolen as soon as you make it? There's no incentive. And
Yeah.
so recognizing that, we both had a learning moment. I was surprised to learn that she had that estimation of Americans, and then part of it. That's part of the situation we have now, and you're right. Most of the world, we're signatory to treaties that we will honor and respect and reciprocate on international copyright law. And so China is not a signatory to that. And
No.
so that, for better or for worse, has a lot to do with the trade war with China. And whether it's been handled correctly or not, historians will probably say no, but there is something to that. There is something to say, hey, we we want it both ways. We want to take our products and sell it in their market, but we also don't want them to steal it. And so it's stealing inventions. It's also stealing software. It's stealing the advances that we made there, and then they sell it to other countries, and we don't get the benefits of that.
Right. Oh,
Maybe I shouldn't
go
have
ahead.
said we. Maybe it's the copyright owners here don't get the benefits of that.
Right, right.
Yeah,
We as Earthicans, somebody's always getting something off of it.
that's right. That's right.
Uh, well, let's see then. I guess if there's any, like I was saying, any salient points that you feel it's pertinent to get out there that you're seeing highlighted currently or in the recent history that, like I was saying, dealing with the
Yeah.
forums and.
Let's riff for a minute on
Okay.
this whole Facebook thing that you just mentioned, and I noticed this for a long time. And I live in that world, and you live in that world. We like to play music, and we go out and we perform, and there's something fun about that. And there's an energy to that, and a lot of musicians have missed that. And so they would go on, and some of them were just like, "Man, just sit down." But they would go on and play guitar and sing to the camera, and they would do cover songs,
Hmm.
and then they would do this and have a little tip jar and do all these kinds of things. And I get it. I get that desire to do that, that desire to connect with the community that they're part of. But the difference is they're not playing in a venue
Hmm.
that has purchased a license, a performance license for copyrighted work to be used. And so I think that's something a lot of people don't really understand. And so maybe we could spend a little bit of time talking about licensing. And
Yes.
and really, there's three different kinds of licenses I think people need to be aware of. There's the performance license, there's the mechanical license, and then finally, there's something called synchronization rights. And so those are three different things. And these three different property interests are things that are individually negotiated and sold and have economic value. And so I think that the performance rights is something, it's something people may be able to connect to sooner rather than later, to understand. Maybe you've gone into that restaurant, that bar, that facility, and on the door you see the sticker. It's a little triangle, and it says ASCAP on it, or it might be BMI, which is another licensing agency. And those things work sort of like the license, the little sticker you put in the license plate of your car. Because they can look at it and see the color. That state trooper knows whether if your tags are expired based upon the color of that. This year it's green, next year it's yellow. ASCAP does the same thing. So they can go by and look at, do you have you displayed your ASCAP? Oh, well, you don't have it. Well, you are in violation. So if you have music playing, whether if it's a band or you're simply playing a radio or a CD or something like that, you need to have performance rights to play that copyrighted music in a public forum. Now, if you're in a place that's streaming something that may be from a music service, maybe they have a business subscription to Pandora or one of these music services, when they pay that fee, it's a more expensive membership than what you and I might have as individuals. The reason it's more expensive because it includes the licensing fees that's paid on their behalf for that business. Otherwise, they got to have the ASCAP license. And if you have a live band in there, you for sure need to have that ASCAP license. So
Yeah, I've dealt with that firsthand.
you have, and so the silly part of that, if I remember your situation, was someone who was playing their own music that they wrote.
Yep.
It's, show us the license. It's like, man, I don't need a license. This is my song. I can play it, but you got to prove that. So that gets kind of funny sometimes. It's kind of interesting that the whole idea of cover. You go to a place, and to get in the door, they charge you a cover charge. It's $5 to $10 to get in, and the origins of that term is supposedly, ostensibly, that cover charge is to cover the cost of the performance license that they are paying. What it's come to be is it covers the cost of paying the band.
Hmm.
And so here's the thing: when I go out and play, and Micah, when you go out and play, it's not our responsibility to make sure that that venue's licensed. It is. I'm taking it on good faith that they have an ASCAP license. It's their job to have that, and so that's part of their business expense. It's getting easier than ever for ASCAP to police copyright infringements in venues that don't have ASCAP licenses. They don't have to go visit anymore. A big case that settled out of court, and it was a $21 million lawsuit in Cleveland, Ohio. ASCAP showed up. They set it down one night. They wrote down every single song the cover band played. They go up to the bar owner and say, show us your ASCAP license. Don't have one. We know you don't have one. We've been sending you letters for 6 months. You keep ignoring them. And they sued them on behalf of all the copyright owners who had registered their copyright with ASCAP. It finally settled out of court. I don't know how much it was, but the lawsuit was for $21 million in damages. Wow, that scares the heck out of people. And so now, since that happened, you walk around downtown Nashville and you go by the venue, and they've got the little chalkboard out up front, and it says, original music, no cover tunes. And they present it as if they want to say, we really encourage songwriters. We want to celebrate songwriters and their music. So no cover songs because we want original stuff. Really, what they're saying is we don't have an ASCAP license. I think really that's what that's about.
Well, something talking about, with Facebook taking down, copyright infringement content that infringes on that. Well, something that I've run into is having my own things taken down
Mm,
because it's being managed by these services, and they say, "Oh, this is a BMI
right,
song,
right.
and no, you can't use it." But I'm turning around saying, "No, I am that dude that wrote this song, so I want to use it in this context." So that's something, and not that you necessarily have an answer to this, but that's something that I've been dealing with on various levels with current technology, getting the rights, going through the proper channels, but still the algorithms, it's still a computer out there saying, nope, nope.
And that's happening across the board. I mean, they are flagging all kinds of legitimate things. The algorithm is not a person, and they can't really get it right. And so some things get kicked down. Something that I do, if I post something that's a cover song, I will get the mechanical license. And when I get that PDF license proof back, yes, you bought the mechanical license. When I post or upload that song, I post that license alongside it. And that doesn't mean the algorithm is not going to kick it out, but it just makes it really easy to say, hey, review this. And then here it is, the proof's there already. Or if it's an original piece of work and you do have the copyright registration in hand, scan it and post it with that song when you post it. That just makes it easier later if someone were to call or do something. And it's just good practice. It's a good practice. And so when I post something, I like to put in, here is our legal excuse to post this song. But yeah, it is a problem, but at the same time, it's a nice problem to have. It's kind of analogous to when the credit card company calls you and says, hey man, this payment you made, did you do this charge? Is that you? Is that you? And you say, yes, it is, or no, it's not. Ultimately, it protects you because these algorithms, on the one hand, it's a pain in the butt when you got to prove, yeah, I do have the rights to this. It's also protecting your work from other people using it in ways that they shouldn't.
Well, let's see, with the mechanical license. Oh, shoot, I was just thinking of something there. Oh, so you were talking about obtaining these mechanical rights.
Mhm.
Uh, how do you go about that?
It's so easy. I mean, 30 years ago, you had to hire someone like me to do that for you, and to register your copyright. And I still do that work. And people say, "Would you copyright my music?" I'm like, here's the link. You could do it yourself, but they want an attorney to do it for them. So okay, I get that. Um, there's lots of services out there. CD Baby will do it for you. I use easysonglicensing.com, and it's like 45 bucks, $15 to research. You fill the form out, and in a few days they'll send you the certificate. And then somehow that artist is going to get paid if your work is used. At least they get a copyright royalty from that. And so that's something that if you don't get a mechanical license, It's not because it's not accessible. It's very easy to do.
Right. And to clarify, this is for someone such as myself. I want to go out and do a. I want to I want to do my rendition
Mhm.
of "The Wall" by Pink Floyd. I need to go through these steps, and I guess that would be ultimately through probably Harry Fox. Uh,
Actually, Harry Fox is something that you would do if you want to have synchronization rights. So let's
okay.
go through what those three rights are. First is the performance rights, which is the right to have a public performance of someone's copyrighted work.
Mhm.
Okay. And then the second type is the mechanical license. And this is a holdover term from the day that it was a mechanical process that, you have this tape deck here feeding 1,000 tapes there to make a copy. It was a mechanical process, but you had to have a license before you copied someone's work. Um, Now, the cover type songs, like if you were to do your rendition of Pink Floyd, that's considered a parody. It's okay to do a parody. You don't have to get permission to do that. You just do the parody. But before you put that into a stream of commerce, before you put that in a marketplace, before you publish it in any form, you need to have a mechanical license so that whoever is the current owner of that Pink Floyd song, that they will enjoy the royalties that may come off of the use of your recording of their song. Now, you also have a copyright interest in that song because you did it with your own artistic expression. So you share in the copyright interest in that. I don't know exactly what that formula is, but I know that pot of money gets split right there. And so when you publish that, you can go on to like a cdbaby.com, easysonglicensing.com, and the mechanical license. It takes you 15 minutes to go online, get that mechanical license. In a few days, they email you the PDF, and then you're good to go. That's all you have to do. Now, you mentioned the Harry Fox agency, and they're kind of a one of a kind. That's a very, very specialty firm out there. And what Harry Fox does is they will secure synchronization rights. They're also called fixation rights. So you may hear both terms is talking about the same kind of license. And this is a license to take someone's work, someone's copyrighted work, and integrate it into something else. So it might be someone's song that you want to make as the soundtrack of your movie or the soundtrack in your commercial. It might be a piece of video or photography or whatever that bit of intellectual property is that now becomes an ingredient in something that you're making. And so before you do that, the synchronization rights have to be negotiated. Now there's no central place that you can go to and say, "Hey, just bought my performance license," or "Hey, just bought my mechanical license." Synchronization rights have to be individually negotiated. And that's really hard to do, and it's very expensive to do. And there are a couple of workarounds that people might do. So for example, if there was a filmmaker who really wanted to have Pink Floyd's The Wall in the soundtrack of their film, Harry Fox agency is expensive. Now if you were Steve Spielberg, you call up the people in Pink Floyd and say, "I want to use your song," and they say, "Great, let's do it, and now let's release a soundtrack album." But most people aren't working at that level of a multi-million dollar film. So the workaround is, I really want to use The Wall in my TV commercial. I can't afford that, I need it tomorrow, but Mike is really good at playing this song. So Micah, would you go ahead and record this song for me? Can I commission you to do a parody of that song? And then if I pay you a few bucks, would you then give me the mechanical license to use your version of that song? And that's what ends up in my commercial or movie or whatever I'm making. So that's one workaround. So if you go watch a feature film, spend a few minutes watching, not like a Steve Spielberg, okay, a lesser film, a lower budget film. And when you see those credits go by, you will see it go by and it'll say, you know, The Wall, written by Pink Floyd, as performed by Micah Barnes. And you'll see that in the credits. Like, aha, okay, that's how they worked around the synchronization rights.
There's a movie. What is it? The Art of Self Defense, I believe. Older movie. And this came up. A friend of mine sent me a link to the song he'd heard in that movie. It's like a really good song, and he was listening to it. And he's like, "Oh, I got to find out who did this." It was a
Mm-hmm.
song he hadn't heard. He's like, "It sounds like Michael McDonald singing." He goes through the credits, looks it up, and the song they had written for the movie and credited to a guy named Donald McMichael.
Oh, okay.
So they had found someone who could do a good Michael McDonald, recorded a song and gave him the name Donald McMichael and wrote it for this. And I know it's slightly off there, but that
But
again they wanted a sound, but they came up with their own. Sorry.
it's one point. I'm glad that you gave that example, because if the parody cannot be exact, it cannot be something that the end consumer will go, "Oh wow, I can't believe they got Pink Floyd doing that commercial." It has to be different enough that it will not confuse the reasonable consumer. And so, an example that a case on point a few years ago. God, I hate this song. If this is someone's favorite song, I apologize. "You Are the Wind Beneath My Wings." I just go on record saying that song just sucks. Okay. Ugh. Okay. And so, it's, okay, that song. Bette Midler did it. I think Whitney Houston did it too. But when Bette Midler is the one who really, really made that sappy, sorry song so famous, and Ford Motor Company wanted to use it in a commercial for their Taurus. So they called Bette up, and they worked through the Harry Fox agency. "Hey, Bette, we want to use your song in our commercial. What do you say?" And Bette said, "No, no, I don't want to do that." "Oh, come on, Bette. No, I really don't want to do that." So they go find someone who sounds just like Bette Midler. You could not tell the difference. And they got her to sing that song and used it in their commercial. Bette sues them, saying, "You have appropriated my image." Now, image could be just what your voice sounds like.
Right.
And so it goes to trial, and people listen to it and go, "That's Bette Midler." Well, no, it's not. And so that was something that was not considered a fair use. It was not a clean workaround of that synchronization right, because she sounded too much like Bette Midler. So if I do a cover song, there's no chance it's going to sound as good as the original. So I'm safe, man. I'll do your soundtrack. There's no legal worries about me being confused.
Well, speaking of current legal issues here, my mic boom keeps dipping on me. The I just saw a couple days ago that I saw Jimmy Page pop up, and apparently they won the Stairway lawsuit. Have you kept up with that at all?
Not kept up with it.
Okay, I didn't read through it. I thought you may have something to add to that, but yeah, the Stairway was, I think, originally from a band called Taurus. It was a song,
I'm kind of sort of. I remember there was something like that. Yeah.
and they were saying, that sounds a lot pretty pretty similar. Was that the song? Yeah.
Those are the kinds of lawsuits that are interesting, and there's a few that come up. And so where this comes into is like, is this a parody? Is it not a parody? And then you get into this really, really murky area. So in fair use is times that it's fair to use someone's copyrighted work without their permission. Okay. So parody is one of them. Educational use, it's very abused. Educational use is where, we're inside of a classroom. I can't use it today because this is being published, but we're inside of a classroom and I can show a portion of a work to illustrate some point. So we got that. There's fair comment and criticism. I mean, if you're going to do a book review, you might want to read, a paragraph. And the same thing with music. We're going to review this album. And so you play just a little bit of flavor, those kinds of things are okay. And then there's one that's had a lot of court action in the last 25, 30 years. And this is the idea of transformative use. And so transformative use is the idea that you use someone's work and you don't have license to do with it whatever you did with it. But your work is so novel and so deserving of its own place in the world that it's okay. And this has been something that has been changing for some while now. The original intent in the Copyright Act of '76 on transformative use was that recognition that we're all fans, and sometimes we may want to express our appreciation of some artist. So, for example, and this is one they talked about in Capitol Hill when they crafted this legislation, is back in that day, people liked to paint pictures of Elvis on black velvet. I know, it was almost as bad as Wind Beneath Your Wings. It was a strange thing. Black velvet, acrylic paint, here's a pic, but it's a one-of-a-kind thing. It's not something mass-produced. and people should be allowed to interact with their culture and express things about their culture. It's not really a commercial thing. Maybe you go to a flea market and you buy that painting of dogs playing poker or whatever it is, but it's a knockoff, it's a one of a kind, really no harm. And that was the idea behind transformative use. And then it started changing in 93 with the song Pretty Woman that Roy Orbison did. And Luther Campbell really screwed up transformative use law for everybody, in my opinion. Are you familiar with the song Pretty Woman?
Oh yeah.
Yeah, you probably played it. It's, Van Halen, I think they did the best cover of it. Yeah. When Van Halen, and RIP, Eddie, okay. But when Van Halen did their cover, they didn't have to call up Roy Orbison. Actually, it was Acuff Music Company of Nashville, Tennessee that owns the copyright. He didn't have to call them up and say, hey, can I record your song? He just did it. He did it as a parody, but he got the mechanical license. Or Van Halen, the band, got the mechanical license. So they were legal just fine. When Luther Campbell did it for his band, Two Live Crew, he didn't. He recorded the song, put it on his album, and did not get the mechanical license. And so he gets sued, and he loses, and he loses, and he loses, and he keeps appealing. It goes all the way to the Supreme Court. I just think it's amazing that the Supreme Court of these United States sat around listening to Roy Orbison's version of Pretty Woman and Two Live Crew's version of Pretty Woman, trying to determine whether transformative use was at play. Time well spent by our justices. And so when Luther, instead of Pretty Woman, he's, it's Big Hairy Woman. Big Hairy Woman. And it was kind of rude and crude and socially unacceptable. But anyway, there's that. And he won. And he won. And the court started asking questions that weren't part of the Copyright Act of 76. They were saying, did he steal the essence of the song? Well, the essence of the song is dun, 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 or whatever that is, that line. Yes, he did, but the court said he didn't. And then they asked another question. Did it do economic impact to Acuff Music? Did they lose sales of the Roy Orbison version because of the new one? And the answer, they said, no harm, no foul. And so that is where I think this crazy idea has come up where, well, if you don't make money, or if it doesn't, or more accurately, it's not if you do, if I didn't do economic damage to the copyright owner, then it's okay. And that really kind of put things in a state of flux for a number of years. And transformative use justified all kinds of crazy things. Google Books. Google decided, all these books that are on paper that aren't digital, let's scan them. We'll transform them into digital documents without permission and publish them. And they did, and they won. And they won. And things started to turn around about 2013 and then 2014 until finally we get to the case of Marvin Gaye, his estate, Gaye versus Thicke. And they said, hey, it's transformative use. What was strange was the Thicke estate, this is a song called Blurred Lines. Mm-hmm. And I can't remember the Marvin Gaye song. I hear it in my head.
I'm blanking.
Yeah, I'm blanking, but and you listen to them, the Marvin Gaye song is way better. I didn't think they sounded that much alike, but the thing is, Alan Thicke and Pharrell sue, saying, we want the court to say that our song is not like theirs. It's a copyright infringement. I think it was a publicity stunt. Mm-hmm. And the court came back and said, okay, you think it sounds like it? It's copy. The family sued back, and they lost, Pharrell and lost like $7 million over copyright infringement. The songs aren't alike. So the court recently has been pushing back and coming back to a more traditional use of transformative use. But here's the thing: when it comes down to it, at the end of the day, transformative use, if you want to go there and take the chance of getting sued, you might go there and never get sued. You can break copyright law for years and never, ever have any consequence. It's like speeding, you know? You slow down when you know you might get caught, and then you take off. And so, and then, even if you are guilty, people may decide, he's just not worth suing. It's going to cost this much money. I'll spend thousands of dollars to sue this person and get judgment against them, but they don't have any money to pay me. It's not worth suing them. Ouch. So I'm saying, well done, Facebook. Thank you. Thank you for looking out for people's copyright interests. Excuse me. I promise that wasn't COVID. Thank you, Facebook, for looking out for people's copyright interests, because otherwise, and they didn't have to. They didn't have to do that because Facebook and other internet service providers are protected by a federal law. It's called Section 512 of the Digital Millennium Copyright Act. And what that says is that internet service providers are not responsible, will not be held liable for copyright infringements from people who post things on their sites and their pages. So they didn't have to do this. I do think they're being a good corporate citizen by saying, this isn't cool. YouTube is a good corporate citizen in that they try to police this a little bit as far as protecting copyright. And when you consider that this is 38.2% of our gross domestic product, yeah, we need them to do that.
Now, with YouTube, and if what is their approach to it? Because I know, let's see, if I go on there and I post a song I post something that's got Pink Floyd in there, and they will send me a note.
Okay.
And says, "Hey, we saw there's some copyrighted material," or maybe not Pink Floyd since we're dealing with a different company there. I'll say if I have a Marvin Gaye song,
Okay.
and it's in the background or whatever, and they say, "Hey," they give me these options, and I haven't looked at the options lately to see what they have updated them. But one of them is that I can monetize it.
Okay, yeah.
And leave it up there, but it's going to come with commercials and all this kind of stuff. Can you speak to any of that?
Yeah, what they're working with, there's a couple different issues there. The first one, let's talk about that Digital Millennium Copyright Act, here and after DMCA 512, we'll just call it 512 provisions, has this takedown thing where now YouTube will go ahead and say, we're not sure about that. Maybe you should take this down. It doesn't look legit to us. It's been flagged by our algorithm. But the way the law really contemplates is that the artist would say, hey, now think about this. Can a copyright owner reasonably be expected to monitor all of the world to see when their stuff shows up and where? And, we need those algorithms to work for us. But if you see that and you're aware of it, you can say, hey, Micah just posted something that is ours, and he did so without permission, and we want him to take it down. And so what the ISP does, in this case YouTube, would say, we've been contacted by the copyright owner. He told us to take it down, and so we're taking it down. They contact you. At that point, it usually stops right there. But at that point, you could go back to YouTube and say, actually, I do have legal excuse. Put it back up. And then they do. Now, the dispute is between you and the estate of Marvin Gaye, and YouTube, as long as they follow those rules, they're out of it. They cannot be sued. They cannot be named in a lawsuit as long as that procedure is followed. But they're a little bit more proactive in that they do have those algorithms. Now, if you look, there is a list within YouTube where some artists are saying, well, we're all right. We're okay. We will allow my song to be used. Al Green does this. And it's great because I had a video of a song that we did by Al Green. I wanted to post it, and he was a signatory to this. That says, hey, go ahead and put it up. Just attribute that this is an Al Green song. And if this thing gets enough play, it gets enough hits, then YouTube will monetize it, and I will share in that revenue stream. And there's a growing list of artists who are saying, yeah, go ahead and use my stuff. They see it as something that is going to be a revenue stream for them potentially. So they're okay with it. And I think their attitude may be, people are going to rip me off anyway and use my song. So I might as well try to get in on some of the revenue. So you have that. Otherwise, as far as the revenue, I really can't speak much to how that works. I know it's a thing. I know that some people can earn revenue when they get a lot of ad traffic and things on YouTube, but I'm not really sure how that part of it works.
Sure.
Have you had that experience? Are you getting any paychecks from YouTube?
No, no, I, I have not gotten any YouTube paychecks, but maybe I should look into that. Maybe.
We are educators. We need to get some, yeah, different revenue streams.
Oh, I just had an idea and I forgot to write it down. I was going to ask you. Well, oh, I have one student who's talking about she's doing her project on the royalties in the digital age,
Okay.
and I don't know if that's within your purview of things to discuss how that falls in, but talking about how royalties work out
Right.
and what changes we're seeing and how that works out.
Well, I know that people have choices now. And so you can, when you create a new work, you own it the moment that you create it. So when you get a copyright on it, all you're doing is getting basically a title like you would on your car or something else. It's just, a government issued proof of ownership is what a copyright really is. But you don't have to have that to own it. You own it anyway. And so some people are not going through ASCAP. Sometimes they're going through a music agency, a digital platform, a streaming platform, and then they send it there. And that platform says, okay, we recognize your ownership. You have registered with us, and now you can start. We'll start seeing the revenue stream to you on your royalty payments. And so they're kind of standing in the place of an ASCAP or a BMI as far as, now ASCAP does not issue the license. You go to the Copyright Office to get your license, and then ASCAP then monitors that database. That's how they keep up with who owns what and know who to send royalty things to. But if you don't do that, if you don't want to do that, you can go ahead and say, okay, Spotify, or okay, whatever streaming service, I'm registering with you. And I'm not sure that's the best protection. I'm not sure that that is the best way to say, I don't know if you can mix and match, if you can do both, but there's something about having the government agency saying, this is a government issued title to your work,
Mm-hmm.
rather than saying, here's a Spotify recognition of your work, And so when they take that, can they really know that it's your work? They're just taking your word for it, that this is yours, and maybe someone else's entirely. So I'm not sure that's entirely worked out yet. I know it's a thing. I know a lot of people who are doing it, and they're making some money. So, okay.
And that's something else too. I guess to clarify, that was an eye opener for me as a young musician. The difference between your copyright and the royalty, that those are just completely disparate.
Right.
They couldn't be more far apart. So knowing that I had to go register my work to have ownership, but it could be played on every radio station 24/7 in the world, and I would never see a dime without having it. If I didn't have it under one of the PROs, the BMI or ASCAP or CSAC.
That next step, just registering it doesn't really do it. Um,
Yes.
yeah, and so of course BMI and ASCAP are the ones that basically are here. I think CSAC is mostly classical music and that sort of thing.
Yeah, I think they carry Bob Dylan, and then yeah, and otherwise it's like some weird. They have just a handful of people that you know by name, and everything else is
Yeah.
yeah, they're an oddball out there. And in this digital world, again, I'm curious if there's going to be a whole new approach to this because in the digital world, like Pandora, we know exactly how many times a song is being played for how long to which we've got very granular records. Back when I was in my heyday of royalty checks, it was the way it worked back then was the radio stations had to fill out log sheets,
Yes.
and then BMI would randomly select radio stations because they couldn't go through every one of them, I guess, just the manpower. And they would take out like 10 radio stations and say these 10 radio stations represent every radio station out there, like an electoral college of sorts. And if you were being played on that radio station, hey, suddenly like we were drawing some paychecks, but if we could have been on 2,000 radio station if we weren't one of those 10, we didn't get zip.
That mechanism is still in place. And so called reporting stations. WDXR, which is our local radio station here, is a reporting station. And might be why Lou Vuitton is like the number one R&B artist right now, because that radio station, has his music on quite a bit, and Lou's cool, man. He puts our music on too. He really puts the local people on, and everybody's showing up on charts now because that's a reporting station. That's still there, and so they use some statistical analysis and say, okay, based upon this statistical model, here's how we're going to split up the copyright pool. But yeah, you're absolutely right. We know exactly how many times something's been played on a music service when you call that song up, and so. And Pandora, even after a while, will say, "Are you still listening? Or are you still there?" Because they want to verify that there you are. What's really interesting about that is it's more than just how many ears are hearing the song. The psychographic data they can collect is amazing. And so instead of parsing people out by gender or race or income or whatever, it's like, wow, this guy listens to a lot of bossa nova. Let's throw another song at him like that. Oh, you like Stan Getz? Well, okay, here's something else. And so you're discovering artists that kind of attach on. I think it's amazing that right now, one of the number one albums in the country is a 1970 album, 70s album released by Fleetwood Mac.
Mm-hmm.
Isn't that amazing? And it's because, I think some skateboarder somewhere made a bunch of videos using their music, and people went, man, that's pretty good. And it's just taken off all over again. So, yeah.
Yeah, and Phil Collins just had a massive resurgence with "In the Air" because of some fluke YouTube reaction video that these brothers.
I love those videos. Yeah. Yeah. I watch those things. Yeah.
Yeah, it's just like this whole generation, like just like what we did, growing up. And I remember hearing Hendrix, like, oh my goodness. Of course, everybody who was more than 10 years older than me was like, well, yeah, it's Jimi Hendrix. We've been hearing him our whole adult life. But for me as a youth, hearing that for the first time, I felt like I was discovering this new music. And
yeah, the thing that's amazing about it is it's the Fleetwood Mac album that's taken off. And so that surprised me because, I think that we've become a culture of, here's a song, here's a song, here's a song. And of course, back in our day, you go and buy the new album when it comes out and you drop the needle and you sit down and you listen to that whole side of that album and your friends come over and that's how you did it. Not so much anymore.
the whole idea of a packaged album as opposed to the individual songs out of it. Well, there was I think it was some of the ELO songs that was it Jeff Lynne?
Yeah, yeah.
He went back and re-recorded some parts. I had heard this. I haven't checked on this, but I was thinking a few years ago there was some. He was having issues royalty wise, so he went back and retracked all or parts of the originals and
Okay.
re-released them so that they would not have the issue with royalties and with past members and such.
That's interesting. So the new digital release is something that now all of a sudden he's cleaned up the copyright issues with it.
Yeah. The Journey. Steve Perry's no longer with. They got that guy from the Philippines that they found who just sounds like a dead ringer for him, and they went back on tour and they made like a whole documentary about it. But they did the same thing. They went back and relayed the vocal tracks with this new guy. You can't tell it. I mean, it's the same
Oh,
music.
sounds like the Bette Midler case all over again. I mean, if the guy sounds so much like Perry that you can't tell the difference, I don't know.
Yeah, Don't Stop Believing. It's the name of the documentary about. It's pretty interesting. It's more about this kid's rise to stardom from just abject obscurity on a little island in the South Pacific, and now he's massive worldwide because he's the front man for Journey.
Hmm.
But yeah, from a copyright perspective, it's a very interesting.
From a copyright perspective, it's interesting. And then the other legal issues that come up is use of likeness, use of image. And
Mhm.
so if it's too much of a dead on ringer, then Perry could go, hey, wait a minute, no. You're too much like me. You're using my image. So there are other things at play than just copyright sometimes.
Yeah, well, 10, 15 years have gone by and he hasn't said anything, so I guess he's going to let it ride.
And sometimes people are like, okay, I'm not going to worry about it. That's part of it too.
Well, let's see. I was just thinking over some other topics there. We've pretty,
Oh, we've had a lot of stuff.
yeah, we've really raced through it. Was there anything that we've discussed that you feel like we should unpack a little bit more for the benefit of anybody who's, you know, completely unfamiliar to any of this?
Something that I would just advise some caution and to be careful about. Um, there, there's there's a tendency, there's a thing out there. It's called copy left as a generic term to describe content that is sort of the opposite of copyright. And copy left is the idea of here's some stuff that's free to use. Public world, you can have this. I'm uploading it, I'm posting it. Go ahead and take it and use it. And so people do, and it could be images, it could be songs, it could be software code, it could be all kinds of things. And so this gets out into the world, and then um, some of these, like Creative Commons, might be an example of that you may have heard of. And they say, okay, you can use it, and all you have to do is give me attribution or whatever. The thing is, you don't know who it is that uploaded that. They're representing to you that they have the rights to something that they're going to give to you, and you don't know that. So someone that you don't know who they are or where they are has provided content that they say, hey, go ahead and use this public domain. And then you use it and discover later that they didn't have the rights to it. Wow. Or you use it and then you run into the problem that you try to get your copyright on it. And it's like, well, wait a minute. What percentage of this work was public domain? So especially in the world of software, okay, so you use this basic code and added a couple of things to it. Can you really claim that it's yours when most of the content is public domain? And
Mm-hmm.
so those are some of the issues that are showing up in courts now, is the use of this stuff that people thought was free, and then they find out that it's not free. And so if you want to do that, I would suggest that you look at royalty-free sites. And there are some reputable ones out there. Video Blocks is one that I use. They have music, they have video clips, they have image files, they have just all kinds of media content. It's a reputable company. You can download their stuff and use it in your projects. Some of these places also are a great place for you to put your work. So if you wrote that musical score, you can say, hey, would you feature this? Would you put this on? Would you include it? And then they become basically a sales agent. And so if your stuff is getting sold and people are downloading it, then you can make money when you sleep. So there's your music composition. People are now downloading it and using it when they make a video game, and then you get paid some money when someone downloads that clip to bring it down, that royalty-free content. So those are some things I think it's kind of good to be aware of.
I was just thinking about people who are educators going out and with say their concert band at the school and whatnot, and like here we get licenses each semester to give X performances
Right.
of a song, usually one, uh,
Mm-hmm.
and the fact that we record that and archive it, and then suddenly it's accessible via our library. Now this is all like rapidly changing technology, and we can't get straight answers because I don't think people know a lot of times. Just there's the
I think it comes down to the use of it. So if you recorded that performance and then you play it back to that class and say, okay, let's do a debrief here. It's sort of like the coach who looks at the game film. Hey, if you cut left instead of right, you might have made the touchdown. So if you do that and you take that performance, then within an educational, non-broadcast, non-published,
Mhm.
but face-to-face classroom, you say, let's watch that performance and see what we can learn about a performance so that we can up our game the next time, or we can discover what we did really well, or whatever your debrief is. That would be a legitimate use of that recording. And so if you want to house it in the library and say, here it is, you might want to use that in a future class for the educational use. I would restrict it so that it's not available for public checkout, because what publication is The very simple legal definition of publication is you've rendered something in a recorded form where third persons can access it.
Mhm.
And when
Right.
you put it in the library, unless you restrict, if you want to say, hey, keep it for me, I'll be back to get it next semester, that's one thing. But if it's there for circulation, that was something I would think would be a copyright violation. Now, here's the thing, you can get away with it, you know. Um, I try to be careful. Um, and it's hard. This is a very, very hard time to be mindful of copyright law, and just image law and intellectual property. Um, I try to be mindful of it because I want to provide a good example to my students. And something that I caution them about is, when I was working in the world and industry, when someone gave me their demo reel, gave me the portfolio, if I saw what looked like copyright violations, they went on the reject pile, because you got to take those things seriously, because it's not just you taking that chance, you're exposing your employer to risk, you know,
Mhm.
when you do that. And then of course there's the ethical aspect of it as well. And so they're useful things, they're useful tools that we can use, but publishing them is something a little bit difficult. Something that I think is a real big issue right now. And people don't, and people aren't breaking copyright laws because they're evil people.
Right.
And I got to tell you, if you want to look at some copyright violations, just take a look at some memes out there, and they're hilarious and they're good. And I guess they're public commentary and this and that, but really, you know, there's some stuff out there. It happens, and they don't get in trouble for it. But right now in the world, we've all moved online to teach because of COVID, and so many of us have a repertoire that includes film clips, um, visuals, things that are copyrighted use that are okay to use inside of a classroom, but they're not okay to use in the format that we're in right now. Ouch. Now, a lot of instructors don't know that, and they're doing it and they're using it. And it's not because they're bad people, they just don't know. And then the other thing that I think is a real problem, and I'm careful with my classes, is if I record a lecture, because I think I may want to use it again sometime, I tell my students, look, for this first 20 minutes or so, I'm going to be on screen recording this lecture, and then I'm going to stop that recording, and then we're going to have our class discussion, because I'm careful not to record their image, because it's their image. And I don't have the right to take their image and show it to a future class if I want to use that lecture again. And something else between me and you, when they come around saying, teachers, we're going to take your intellectual property, now you're going to teach 6 classes instead of 4 because 2 of them you already got recorded. I want to say, you don't have the right. Maybe you own the intellectual property. That's question. Maybe it's work product. Maybe I created this, but you don't have the rights to my image. You don't have the rights to use my appearance. You don't have the rights to use my voice. I've never signed those rights over to you, institution. You don't have them. That's the protection that we have in saying, no, you don't have the rights to my image. And so I think that as all of us are going about teaching online, it's something for us to be mindful of, how our image is used and what we agree to.
Yeah, I have not considered that angle on it, but that's spot on.
And so, I don't know if you're teaching by Zoom, but I do a screen capture to take attendance. And then I throw that file away. And I got permission from my students to do that. May I take your picture? I'm not going to publish it. After class, I'm going to sit down and do my attendance records based on who I see on the screen. And then I'm going to throw that picture away. And so I haven't published it. And so that's, I think, an okay use. But beyond that,
Hmm.
it's a problem.
And in cases like right now, where I am recording you for later broadcasts, and I've made you aware of this before thing, Zoom also, I guess, on your screen told you when I hit the record button.
I accepted it, and
Right.
at that point I had a choice to say, man, I'm out of here. I'm sorry, I'm not going to do this. But I was aware. And so, and I also knew what the purpose of this recording is. Probably going to be online. I hope to get a copy of it, a link to it. So I might want to use it somewhere. But yeah, but we worked this out. But think about people who signed up for a class and that class is now online. Do they really have a meaningful choice
Hmm.
of whether they want to be on camera or not, or published or not? I don't know they really have a choice. And so I try to respect their privacy of the use of their image when I'm recording classes like this online.
Yeah,
It's
not to get in the weeds, but I know with Zoom, you can have the option to turn off your camera and put up an image.
Right.
You
Yeah.
know.
And I don't do that because I'm just a difficult teacher. I'm like, if you're not on camera, you're not there, you know. And every once in a while, I'll call on a student and say, "Hey," and then they'll unmute themselves, and they've got music on so loud, there's no way they're hearing anything. I, I'm teaching freshmen for the first time in 30 years. You got to police it a bit more.
As they set down their Xbox controller to
And then oh, I'm sorry, professor, my audio cut out for a second. I have to confess, there is one screen capture that I kept. I haven't thrown it. It's when everyone signed off of the Zoom session. All the little boxes disappear, and it was me and one student, and she was sound asleep.
oh.
So when she asks me about her midterm grade, I'm going to give her that picture. So there's that. We touched on a lot of things. We talked about, the three major forms of licensing, and we talked about some contemporary problems that we're seeing show up with it. And so, this is more than what a lot of people have ever thought about regarding, copyright law. So at the end of the day, I think the best that we can do is try to have that ethic about being mindful of other people's property. And just because we can make a copy of it and they don't even know about it doesn't mean that we didn't steal it. So having that sensibility, I think, is a good thing.
All right. Well, man, I sincerely appreciate you giving me the time for this today, and I'm pretty sure everybody else is gonna really appreciate it as well. So,
Sounds great. Well, send me a link. It was good to see you again.
likewise, you take care of yourself.
If you guys are playing anywhere, I'd love to go hear me some 27 B-stroke 6.
It might be a month or two before we're back in the same building.
I got to tell you, I was commuting to Murray the other day, and I had my iPhone on shuffle, and one of your songs came up, and it just plays whatever artist comes up. So
Right.
somewhere one of your songs came up, and I just cranked it up and jammed all the way into Murray with it. It was good stuff.
Well, 3/5 of us are here in the teaching in this department now.
That's great. That's fantastic. Yeah, good stuff.
Well, I'm going to go ahead and kill the recording now, and